Family-based immigrant visas. Who qualifies? You and several of your friends, all of whom are foreign nationals living and working in the U.S., get together for dinner one night. Being from all over the world, the conversation naturally turns to home and family. Jose, who is in the U.S. on an H-1B visa, wants to bring his little sister to the U.S. to take care of his kids. Benjamin, a green card holder from Israel, talks fondly of his fiancée and wants to have her come to the U.S. so they can get married. Puna, who just filed for naturalization, talks of bringing his aging mother and his sister to the U.S. to live with him. Albert, from England, who is in the U.S. as a permanent resident, wants to bring his wife over. And Kenji, who was naturalized just last week, talks of bringing his parents and cousins from Japan to the U.S. The big question, of course, is which of these family members will qualify for a family-based immigrant visa? Each of these individuals have heard so many stories of who you can and can't bring to the U.S., but none of them is sure what the law really is. Just about that time, the doorbell rings, and Dan, another friend, arrives. As you fill him in on the conversation, find out that his brother-in-law is an attorney who specializes in immigration law, and that he can get some answers for you. Let's see what he found out. We present here a short overview of the law as it pertains to family-based immigration. Family-based immigration. The U.S. Congress, by conferring permanent residence eligibility upon certain family-based groups, has properly recognized the importance of family unification in American immigration law. The Immigration and Nationality Act, the INA, provides for immigrant visas for certain foreign nationals based on their relationship to U.S. citizens or legal permanent residents. Family-based immigration falls under two basic categories: unlimited, or immediate relatives of U.S. citizens, and limited, the preference categories. Approximately 500,000 family-based immigrant visas are available each year. Let's start with the unlimited family-based immigrant visas, or the immediate relatives of United States citizens. The first category of family-based immigrant visas is for immediate relatives of U.S. citizens. Within this group are spouses of U.S. citizens, unmarried children under the age of 21 of a U.S. citizen, and the parents of a U.S. citizen who is over 21 years old. Spouses. The spouse of a U.S. citizen will qualify as an immediate relative. However, it is very important that the marriage is legal in the country where the marriage took place, and it is not in contravention of U.S. laws. The actual ceremony in the jurisdiction where it was performed must be legally recognized, and all legal requirements, including registration of the marriage, must be met. For example, a common law marriage must meet the legal requirements and be recognized in the country where the couple lives to qualify for immigration purposes. The simple fact that two people have been living together, no matter how long they have lived together, does not constitute a legal marriage. If either the husband or wife has been previously married, a legally valid divorce must have taken place. This can be a problem in countries that do not recognize divorce. Let's go to children. To qualify as a child for immediate relative status, the child of a U.S. citizen must be unmarried and under the age of 21 years. Within the context of U.S. immigration law, child is very specifically defined. This definition includes children both born in and out of wedlock. But for those born out of wedlock, the qualifications for immigration differ depending upon which parent is sponsoring the child. For children born in wedlock, the relationship to either the father or the mother will be sufficient to qualify the child for an immigrant visa. For children born out of wedlock, the relationship through the mother will always qualify because it can be easily proved. However, the relationship through the father will qualify in only two circumstances. The father must show that 1, evidence exists, such as the father financially supporting or living with the child, which clearly demonstrates that a parent-child relationship, or 2, the father, while in legal custody of the child and before the child's 18th birthday, has, quote, legitimized the child in the manner prescribed by the law in the country where the father and child were living. Stepchildren, adopted children, and eligible orphans are also included in the definition of child. Stepchildren are treated as as a child of the beneficiary as long as the stepchild relationship was created before the child's 18th birthday. Adopted children are considered children for immigration purposes as long as they were legally adopted before the age of 16, and they have been in the legal custody and physically resided with the adopting parent for 2 years. Eligible orphans must meet the very specific definition of orphan within the USCIS law to qualify. Parents. The parents of a U.S. citizen are eligible for a family-based immigrant visa, provided that the U.S. citizen child who is filing the petition for his or her parents is at least 21 years of age. Additionally, the U.S. citizen must be the, quote, child of the parent seeking permanent residence, as child is defined by immigration law, as we talked about before. Let's look at advantages based on immigrant visa for an immediate relative of a U.S. citizen. Seeking permanent residence as an immediate relative of a U.S. citizen has substantial advantages. The main advantage of the immediate relative status is that the number of visas issued each year is not subject to any numerical limits. The greatest disadvantage is that there is no derivative status for dependents of the immediate relative. Every family member has to independently qualify as an immediate relative of the U.S. citizen to be issued a family-based immigrant visa. Qualified immediate relative applicants are never forced to spend time on a waiting list, and if the immediate relative legally in the U.S. and are otherwise qualified, they can always file for adjustment of status. However, spouses and U.S. citizens who have been married for less than 2 years at the time they get their green cards are subject to a 2-year period of, quote, conditional, end quote, residence. Because of this, some of these individuals may elect an employment-based path to permanent residence. Let's go to limited family-based immigrant visas, or the preference categories for family members of citizens or residents. The second group of family-based immigrant visas is for certain family members of U.S. citizens and legal permanent residents. While the U.S. Congress has found that these relationships provide important family ties, they do not rise to the level of the immediate relatives. Unlike the visa category for immediate relatives of U.S. citizens, the number of immigrant visas available to the preference categories is subject to annual numeric limits. Let's look at these family preference categories. These family members have been separated into green card preference categories based on the closeness of the relationship of the beneficiary to the petitioner. Within the preference categories are unmarried children of U.S. citizens, spouses and married children of permanent residents, married children of U.S. citizens, and brothers and sisters of U.S. citizens. The numerical limit. Because of the numerical limitations on each of the categories, there is generally a waiting period before a beneficiary, the sponsored relative, can get a visa and come to the U.S. The wait times are listed in the State Department's Visa Bulletin. They currently range from 1.5 years for the spouse of a permanent resident to approximately 20 years for the brother or sister of a U.S. citizen originally from the Philippines. These family preference categories, in order of preference, are as follows. A. Family First Preference, the F1, unmarried sons and daughters of U.S. citizens. The reason these individuals are not qualified under the immediate relative category is because they are over the age of 21 years. In order to be an immediate relative, each son or daughter must have met the legal definition of child, i.e., he or she must be under the age of 21. When an individual reaches the age of 21, Congress determined that they were no longer dependent on their parents and could wait for a visa. This preference category is given 23,400 visas each year, plus any that are unused by the fourth preference. Family-sponsored second preference, F2s, spouses, unmarried children, and unmarried sons and daughters of permanent residents. The family preference category is subdivided into 2 subgroups: the immediate family members, the spouses and children of permanent residents, and unmarried adult sons and daughters of permanent residents. The entire category is given 114,200 visas annually, plus any unused visas from the first preference category. with the vast majority going to the immediate family member subgroup. As with immediate relatives, a spouse of a permanent resident is granted permanent resident status on a conditional basis for 2 years if they have been married for less than 2 years at the time the permanent residence is granted. But because of the wait times required, it is rare that an F2 spouse will be given conditional status. Also, as with the immediate relative spouse, if after 2 years the marriage ends or is found to have been a sham, the residence will be terminated. Family third preference, the F3 category, married sons and daughters of U.S. citizens. Married children of U.S. citizens do not qualify as immediate relatives for immigration purposes, solely because they are married. Again, Congress determined that if they have married, they're not dependent upon their parents. They can wait for a visa. This group receives 23,400 visas each year, plus any unused visas from the first 2 preference categories. As always, each son or daughter must have, at some earlier point, met the definition of child for immigration law purposes. Family fourth preference, the F4 category, brothers and sisters of U.S. citizens. The brothers and sisters of a U.S. citizen qualify for immigration, but only if the petitioning citizen is 21 years of age or older. To qualify under this category, the sponsoring U.S. citizen and his or her sibling must both meet or have met the definition of child in relationship to the same parent. Derivative status. The immediate family members, the spouses and unmarried children under the age of 21 of immigrants qualifying under each of these 4 family preference categories are permitted to concurrently immigrate as well. Documentation that is required. The documentation needed for a family-based green card petition for permanent residence is the same for immediate relatives and family preference applicants and are as follows. INS Form I-130, a petition for alien relative, supporting documentation that shows that the petitioner is a U.S. citizen or lawful permanent resident, and a qualifying relationship between the petitioner and the beneficiary, the intending immigrant, exists. A Form G-325A, biographic information form, and 2 color photographs for both spouses, but only if the qualifying relationship is marital and under either the immediate relative or second family preference category. INS filing fee of currently $355, and a Form G-28, the notice of appearance of attorney or representative if they are represented by counsel. The I-130 package is filed with the USCIS National Benefits Center. The processing time for the I-130 will depend on which family-based category the beneficiary falls into. If they are immediate relatives, the processing time is currently 3 to 6 months. For the preference categories, the processing times are 2+ years, depending on which preference category is involved. Concluding here, family-based immigration has many benefits for U.S. citizens, permanent residents that want to be reunited with family members, be it a spouse and children, a newly adopted child, or brothers and sisters. The closeness of the relationship will determine if the foreign national can be sponsored under the family-based categories, and if they can, how long it will take for them to get the immigrant visa. Now let's go back to our dinner party and see who will be able to bring their relatives to the U.S. and how long it may take them. Starting with Jose. Jose is here on an H-1B visa, so he will not be able to sponsor any relatives for permanent residence. He cannot bring his little sister to the U.S. to help care for his children. Benjamin. Benjamin is a permanent resident, so he is not able to sponsor his fiancée until they get married. Once they marry, she will be the spouse of a permanent resident and will fall into the second preference category. According to the State Department Visa Bulletin, it will take approximately 1.5 years once Benjamin becomes a naturalized citizen. His fiancée or wife will become an immediate relative and would not have to wait for a visa number. Puna. Puna is still a permanent resident, so cannot sponsor either his mother or his sister. However, once he is naturalized, remember he just filed his naturalization application, his mother will be an immediate relative, no wait, and his sister will be in the fourth preference category. Based on this month's visa bulletin, who and his sister will have about a 9-year wait. Albert's situation is similar to Benjamin's, except that Albert is already married. He can file a Form I-130 for his wife right now. Like Benjamin, once the petition is filed, Albert is looking at about 1.5 years before his wife can join him. Kenji is that naturalized U.S. citizen, so his parents are immediate relatives and can come to the U.S. relatively quickly, taking only the normal processing time. However, there is no category that his cousins would fit into, so he is not able to sponsor them. If you have any questions about your eligibility or steps to be taken in a family-based immigration visa process, consult a Visa Pro immigration attorney. We will be happy to guide you through that process.